Hi there, I'm Jenson. Today is Friday, June 24th, and today the United States Supreme Court voted to overrule Roe v. Wade. But what exactly does that mean, and what, if anything, comes next? Let's get you in the loop. First, what exactly is Roe v. Wade? Roe v. Wade is the name given to the lawsuit filed in 1970 that led to the Supreme Court decision establishing a constitutional right to abortion in the United States. So here are the basics. Jane Roe was a pseudonym for Norma McCorvey, who was 22, unmarried, unemployed, and pregnant for the third time in 1969 when she tried to have an abortion in Texas. Henry Wade was the district attorney of Dallas County, Texas at the time. McCorvey's team argued that Texas law was unconstitutionally vague and violated her constitutionally protected right to personal privacy. So the question before the court was this: does the Constitution recognize a woman's right to terminate her pregnancy by abortion? Ultimately, in 1973, the court said yes, with a 7-2 majority opinion. Justices held that a woman's right to an abortion was implicit in the right to privacy protected by the 14th Amendment. So they divided pregnancy into 3 trimesters and decided the choice to end a pregnancy in the first trimester was solely up to the woman and her doctor. In the second trimester, the government could regulate abortion, but not ban it in order to protect the mother's health. And in the third trimester, the state could prohibit abortion to protect a fetus that could survive on its own outside the womb, except when a woman's health was in danger. But, of course, that's not where the discussion ends. In 1992, the court heard Planned Parenthood v. Casey, a challenge to Pennsylvania abortion laws that included a 24-hour waiting period. In this case, the court did uphold the right to abortion, but they also made it easier for states to regulate it. Now, neither side was exactly pleased with this ruling, and since then, a number of states have enacted tough restrictions, bringing even more court challenges, including a recent Texas law banning abortions after about 6 weeks. So let's jump ahead to what's happening now. What is this case that toppled Roe? That would be Dobbs v. Jackson Women's Health Organization, a challenge Mississippi's ban on abortion after 15 weeks. Here were the stakes. If the court decided to allow that 15-week ban, it would undermine the court's previous rulings. Under the precedent set by Roe and Casey, states were allowed to regulate, but not ban, abortion up to the point of fetal viability, which is at about 24 weeks. Last month, a draft opinion in this case was leaked, which led Americans to believe the Supreme Court majority would uphold that ban and overturn the federal right to abortion. And today, that's exactly what they did. In today's final opinion, Justice Samuel Alito wrote that the court decisions made in both Roe and Casey were wrong the days they were decided. He said, "We therefore hold that the Constitution does not confer a right to abortion. Roe and Casey must be overruled, and the authority to regulate abortion must be returned to the people and their elected representatives." Now, to be clear, this doesn't mean that abortions are now illegal in all states. States can still pass their own abortion laws that either restrict or guarantee the right to an abortion. And in the hours following, President Joe Biden addressed the nation, saying the ruling puts the health and life of women at risk.
They didn't limit it, they simply took it away. That's never been done to a right so important to so many Americans. But they did it. It's a sad day for the court and for the country.
And leaders in Ohio and Michigan are already on the move. Ohio Governor Mike DeWine held an evening address asking people to be civil and said his administration is looking to raise awareness about pre- and postnatal care along with other options.
We'll be working on efforts to increase awareness about adoption, to ensure that every child finds a permanent, loving home and family.
And shortly after that, Attorney General Dave Yost tweeted that the state's heartbeat bill is now law. In 2019, Ohio Governor Mike DeWine signed the legislation which prohibits abortions after the first detectable fetal heartbeat, which can occur as early as 6 weeks into pregnancy, before many women know they're pregnant. A federal judge blocked that law shortly after DeWine signed it, but just hours after today's Supreme Court decision, Yost filed for the injunction to be lifted. But up in Michigan, things are a little bit complicated. A dormant 1931 law bans nearly all abortions in the state, but it hasn't been enforced since Roe v. Wade. Governor Gretchen Whitmer has filed suit asking that the state Supreme Court declare the 91-year-old law unconstitutional, but it hasn't acted yet. And Michigan abortion rights supporters hope to put the issue on ballots this fall. So, what happens now? Well, even though the Supreme Court overturned Roe v. Wade, Congress could introduce and pass legislation that would federally protect abortion services. But even then, the Supreme Court could potentially deem that new abortion law unconstitutional in a future case. Lawmakers introduced legislation last year that would codify Roe v. Wade, but so far, it's failed to become law. And we will, of course, continue to keep you updated as more information comes in. But for now, I'm Jenson, and now you're in the loop.